All right, in this video, Jared's going to give us an overview of the bankruptcy process.
So the bankruptcy process usually starts with a client contacting us, wanting more information about whether they should file bankruptcy, what their options are, and all of the above bankruptcy questions. So from there, we generally ask them three basic questions, which we'll cover more thoroughly in another video, but essentially boils down to how much debt they have, what their income is, and if there's any major asset that we can detect pretty easily that could be in trouble of being taken through the bankruptcy process. If all of those things check out, we'll bring the client in, sit down, go through all of their questions that they have, do a thorough analysis of any property that's out there, all of their income, how many children they have, look at the 10,000-foot view of their bankruptcy and their estate as it stands on that day, and see if they really do make a good candidate for filing, or if there are other options out there that really make more sense for them to pursue. From that point, we move into the drafting phase. Now, we take a client in and sit down and go through the entire bankruptcy petition. Other bankruptcy attorneys may send their client home with paperwork to fill out themselves, but regardless, you run through the entire petition, which is about 60 pages, line by line, filling in all of the necessary information. At that point, you've done most of the legwork, and you file the bankruptcy petition with the bankruptcy court, which is the key date in the bankruptcy process. It kicks off the 3-month timeline, more or less 3 months, of your bankruptcy. From that date, it's about a month out where you have your 341 meeting, which refers to the 341 statute in the bankruptcy code. And in that meeting, you meet with your bankruptcy trustee, who is an attorney hired by the bankruptcy court to represent your creditors in the process, and see if there's any assets that he can take to then pay out the creditors. This meeting generally only takes 5 to 10 minutes. You might be there for an hour or two waiting your turn, but it's more or less a rubber stamping process of the bankruptcy court to make sure that they've dotted their I's and crossed their T's. If there is any question that comes up through the petition, they can ask the client directly, the debtor, what is this asset and why is it here, and is it exempt or is it isn't. And the attorney's there, so really pretty smooth sailing. After that, it's 2 months of a waiting game. Generally, nothing happens. This is the point where a creditor may contest the bankruptcy or try to go after a piece of property, but for the most part, it's just waiting for the 2 months to finish out and you get your discharge.